The Trump administration has once again pushed a high-stakes constitutional battle to the U.S. Supreme Court. On Friday, government lawyers asked the justices to review President Donald Trump's executive order that seeks to end birthright citizenship in America. This marks the second time this year the administration has asked the court to intervene, reigniting one of the most contentious debates in U.S. history. At the heart of the issue is the 14th Amendment, which for more than a century has been understood to guarantee U.S. citizenship to anyone born on American soil, regardless of their parents' immigration status. But the Trump administration argues that this interpretation is wrong and has led to destructive consequences. Solicitor General D. John Sauer, the administration's top appellate attorney, wrote that lower court rulings have undermined border security and wrongly extended the privileges of citizenship to hundreds of thousands of people who, in the administration's view, were never entitled to it. Earlier this summer, the Supreme Court issued a ruling related to birthright citizenship, but that decision dealt mostly with the power of lower courts to block presidential policies. The ruling limited but did not eliminate those powers, leaving the door open for ongoing challenges. Since then, federal courts across the country have continued to block Trump's order. One case, brought by Democratic-led states, was upheld by a federal appeals court in San Francisco. Another, filed as a class action by the ACLU in New Hampshire, also prevented enforcement of the order. The administration insists it has a compelling interest in ensuring that American citizenship is reserved for those lawfully entitled to it. But opponents argue the executive order is flat-out illegal. ACLU attorney Cody Wolfsey, who helped argue the New Hampshire case, said no legal maneuvering will change the fact that stripping citizenship from children born in the U.S. is unconstitutional and cruel. The executive order in question, signed by Trump on January 20th, declared that the government would not issue documents recognizing citizenship for children born in the United States to parents who were either here unlawfully or in the country temporarily. Supporters of Trump's policy argue that this interpretation aligns more closely with the 1898 Supreme Court case of U.S. v. Wong Kim Ark, which recognized citizenship for people born in the U.S. who had permanent residence. But so far, lower courts have not accepted that argument. The Ninth Circuit Court of Appeals said in July that Trump's order directly contradicts the Constitution, existing precedent, and decades of government practice. Judge Ronald Gould, writing for the majority, stated clearly that denying citizenship to people born in the United States is unconstitutional and cruel. As the case now heads toward the Supreme Court, all eyes are on whether at least 4 justices will agree to hear it. If the court takes up the case, the ruling could redefine the meaning of American citizenship for generations to come. This story is still unfolding, and we will continue to follow every development closely. Don't forget to subscribe to InsightPulse for more in-depth coverage and analysis of the issues shaping our nation and the world.